What happens when courts serve neither law nor justice? Can liberty in America survive when courts attempt to be experts in everything except what they're actually delegated to? Now, you may have heard about the California church that recently received an injunction from the Supreme Court against Governor Newsom's tyrannical restrictions against churches in California. However, just as the magician distracts his audience while performing the trick out of sight, this injunction is not a win for liberty in the Golden State. It is a knife in the back to the rights of all Americans. And we'll discuss that next on the Constitution Study.
You have to know wherever you make your stand. Came from a long through line of everyday Americans.
Hello there, everyday Americans. Paul Engel here with the Constitution Study. This is where we read and study the Constitution. We teach the rising generation to be free. I'm glad you could join me. We should have an interesting time today. Before that we go, though, please check out the website constitutionstudy.com. That's where you can find these videos, articles, everything I put out, and it's absolutely free for you to use and free for you to share. Carte blanche. Share it wherever you want. Because I think this information is so important that it shouldn't be restricted. Therefore, I don't ask you to pay for it. I ask you to just use it and share it. And so check that out. Find out what's going on. It looks like I'm going to be in North Dakota this August. So if you're anywhere near there, please check out the website, find out when I'm going to be up there, and join in. And if you have an event you'd like me to attend up there or participate in or anywhere along the way, because I'll be driving from Nashville, well, please let me know. I'm interested in stopping along the way and meeting other patriots, other constitutional scholars that are working to restore rights and liberty to this country. So check out the site. At some point, I'll probably put my route up so you can see where I'm going to be. And even if it's just a cup of coffee with friends, I'd love to meet you. And with that, let's talk about this Supreme Court case about the church in California. South Bay United Pentecostal Church has petitioned the Supreme Court to hear its case, or issue a writ of certiorari. This case against Gavin Newsom as governor of California. Now, while waiting for the court's decision on the writ, South Bay Pentecostal has asked for injunctive relief from California imposing these restrictions until the court has decided by the case. Now, these restrictions include the state's Tier 1 prohibitions against indoor worship, along with capacity limits and prohibiting singing and chanting. Now, the injunction issued by the court says the state cannot enforce some of the Tier 1 prohibitions, but leaves in place the capacity limits as well as prohibiting singing and chanting. Now, while some in the faith community have hailed this as a win, both the restrictions left in place and the reasons the justices gave for their opinions show that liberty is now in the hands of 9 high priests in black robes, and that the rule of law is dead. The opinions of the justices were all over the map. Justices Thomas and Gorsuch would have granted the injunction in full. Justice Alito would have granted the injunction against the capacity restrictions in indoor singing and chanting, but would have stayed the injunction for 30 days to give the state a chance to demonstrate that these restrictions were the only way to reduce the spread of COVID. Chief Justice Roberts concurred with the partial grant of the injunction and gave a reason for it that I will explore later. Justice Barrett, who was joined by Justice Kavanaugh, wrote the court's opinion. Meanwhile, Justices Kagan, Breyer, and Sotomayor dissented. So let's start with the court's opinion written by Justice Barrett and joined by Justice Kavanaugh. Quote, "The applicants bore the burden of establishing their entitlement to relief from the singing ban. In my view, they did not carry that burden, at least not on this record. As the case comes to us, it remains unclear whether the singing ban applies across the board and thus constitutes a neutral and generally applicable law, or else favors certain sectors and thus triggers more searching review. Of course, if a chorister can sing in a Hollywood studio but not in her church, California's regulations cannot be viewed as neutral. But the record is uncertain, and the decision below, unfortunately, shed little light on the issue." Once again, we have the Supreme Court ignoring the law and placing their opinions as paramount. While this is not a First Amendment case, the court is using their free exercise jurisprudence as justification for their position. Now, contrary to the so-called experts, since Congress did not pass this law, it is not a violation of the First Amendment. It is, however, a violation of Sections 2 and 4 of Article 1 of California's Constitution. Section 2 reads, quote, "A law may not restrain or abridge liberty of speech or press." And Section 4 reads, "Free exercise and enjoyment of religion without discrimination or preference are guaranteed." Now, this is also a violation of the due process requirements in both the 5th and 14th Amendments to the U.S. Constitution. The 5th Amendment reads, quote, "No person shall be deprived of life, liberty, or property without due process of law." And the 14th Amendment says, "Nor shall any state deprive any person of life, liberty, or property without due process of law." The court seems to think it's quite acceptable to abridge freedom of worship and speech, not to mention to deprive people of their liberty and property without due process, as long as it's done equally. According to Justice Barrett, if the state abridges the rights of both churches and Hollywood studios, that's just fine. Now, this position is confirmed by Justice Gorsuch, Thomas, and Alito in their concurrence. Quote, "Often, courts addressing First Amendment free exercise challenges face difficult questions about whether a law reflects, quote, subtle departures from neutrality, religious gerrymandering, or, quote, impermissible targeting of religion." This is from the Church of Lukumi, Babalu I versus Hialeah. But not here. Since the arrival of COVID-19, California has openly imposed more stringent regulations on religious institutions than on many businesses. The state spreadsheet summarizing its pandemic rules even assigns places of worship their own row. At Tier 1, applicable today in most of the state, California forbids any kind of indoor worship. Meanwhile, the state allows most retail operators to proceed indoors with 25% occupancy and other businesses to operate at 50% occupancy or more. Apparently, California is the only state in the country that has gone so far as to ban all indoor religious services. Again, these justices ignore the language of the First Amendment and apply their own opinions to how freedom of religion should be protected. As long as the state is an equal opportunity infringer of people's rights, the court is more than willing to place their blessing on the tyranny. Gorsuch goes on to show just how corrupt the entire federal judicial system has become. Quote, "When a state so obviously targets religion for differential treatment, our job becomes that much clearer. As the Ninth Circuit recognized, regulations like these violate the First Amendment unless the state can show they are least restrictive means of achieving a compelling government interest." Justice Gorsuch points out that not only has the Supreme Court substituted their own opinion for the supreme law of the land, it appears the inferior courts have as well. Where does the Constitution say that speech, religion, or any right it protects can be infringed if the government claims a compelling interest? The answer is nowhere. And where does the court get the power to place their predecessor's opinion, in the case of Church of Lukumi, Babalu I versus Hialeah, above not only the supreme law of the land, but the oaths the justices took upon taking office? The answer is also nowhere. What officials in California are doing is more than simply promise breaking. This is a criminal act. Title 18 of the United States Code, Section 242 states, quote, "Whoever, under color of any law, statute, ordinance, regulation, or custom, willfully subjects any person in any state, territory, commonwealth, possession, or district to the deprivation of any rights, privileges, or immunities secured or protected by the Constitution or laws of the United States, shall be fined under this title or imprisoned not more than 1 year, or both." Now, these justices are actually accessories after the fact. By depriving the citizens of California their rights under color of law, what they themselves call law, they are just as criminally liable as Governor Newsom. As if the court's malfeasance were not bad enough, Justice Roberts in his concurrence and Justices Kagan, Breyer, and Sotomayor in their dissent go beyond mere sophistry to judicial malpractice. Let's start with Chief Justice Roberts. Quote, "As I explained the last time the court considered this evolving case, federal courts owe significant deference to politically accountable officials with the, quote, background competence and expertise to assess public health. While I agree that, in general, courts should defer to elected officials, that should only be when they are exercising the powers delegated to them within the laws and the constitutions of the United States and their state. Why should the courts submit themselves to the opinion of supposed experts in public health? Is it because they have shown themselves to be infallible in their field of expertise? Is it because of the cultish devotion to those we call experts? Or, as Justice Kagan wrote in her dissent, has the court given up even the pretense of exercising judicial power in favor of policymaking? Quote, Justices of this court are not scientists, nor do we know much about public health policy. Yet today, the court displaces the judgment of experts about how to respond to a raging pandemic. Court justices are not supposed to be scientists or public health experts. They're supposed to be experts in the law, including the supreme law, the Constitution. They're not delegated the power to make judgments based on policy, politics, or pandemics. Their only standard should be the law. Whenever they place something above the law, they are committing malpractice, as defined in the Merriam-Webster dictionary. Quote, a dereliction of professional duty or failure to exercise an ordinary degree of professional skill or learning by one, such as a physician, rendering professional services which results in injury, loss, or damage. This alone should be sufficiently bad behavior for a justice to be disqualified from holding office. From Article 3, Section 1, Clause 1 of the Constitution, quote, the judges, both of the Supreme and inferior courts, shall hold their offices during good behavior. Yet instead, we have the federal judiciary giving their blessing to the infringement on the rights of the people of California, not to mention the rest of the country. And the American people stand for it. This case is another reason why the American people cannot trust the courts with their liberty, as if we needed more evidence of that. We have 7 of the 9 justices on the Supreme Court not only complicit in the destruction of the rights of the people of California, but condoning it as well, at least in part. 3 of those 9 justices are more than happy to have officials in the state of California trash free speech, freedom of religion, liberty, and property rights simply because someone they deem an expert tells them it's okay. Forget rights. Forget the rule of law. This is the exercise of tyrannical power and a foreshadowing of what America will look like in a few years if we, the people, don't stand up and regain control of our public servants. As Abraham Lincoln said, quote, the people are the rightful masters of both Congresses and courts, not to overthrow the Constitution, but to overthrow the men who pervert it. If we are the rightful masters both of Congresses and the court, and I believe President Lincoln might have meant legislature since only the national legislature is called Congress, see, then this mess is our fault. Our job is not to overthrow the Constitution, but to return it to its rightful place. Article 6, Clause 2 of the Constitution reads, this Constitution and the laws of the United States which shall be made in pursuance thereof, and all treaties made or which shall be made under the authority of the United States, shall be the supreme law of the land, and the judges in every state shall be bound thereby, anything in the Constitution or laws of the United States to the contrary, notwithstanding. You may not feel prepared to stand against those in government. This is not surprising, since government-run education system has been indoctrinating generations into servitude for decades. But the cause is not lost. Thomas Jefferson said, quote, I know no safe depository of the ultimate powers of the society but the people themselves. And if we think them not enlightened enough to exercise their control with a wholesome discretion, the remedy is not to take it from them, but to inform their discretion by education. This is the true corrective of abuses of constitutional power. If we are to restore liberty and justice to America, we must take the advice of these 2 presidents. We must again become the masters of our legislatures and courts. We must use the Constitution to overthrow those who pervert it. And if we think we are not enlightened enough, then we must inform our discretion with education. That's the purpose of the Constitution study. The mission that drives our days, to enlighten and inform by education with the truth of the original documents, to empower the citizens of this nation to exercise their powers, restore the government to the consent of the governed, and overthrow those who are perverting not only the Constitution, but liberty and justice as well. If we will not overthrow those who pervert the Constitution at the ballot box, we will doom our children either to live as slaves or to overthrow them with violence. And they will rightly curse us for leaving them the difficult task of restoring liberty because we were unwilling to keep it while the task was yet simple. I know it may be seeming like I'm raining on someone's parade. The fact that the court got the injunction is okay, But again, it's a magician's trick. Oh, sure, we'll let you have in-person worship. We'll set restrictions. We won't let you sing. We won't let you chant. We'll give you crumbs and hope that you'll go away happy. Is that what America is based on? Do you wish to live off the crumbs of the elite's table? Those in Congress, those in government, those in the courts. Do you want to live off of their crumbs? Because that's what they're offering you. But if Abraham Lincoln was right, and we are truly the masters, then we should stand up and do something about this. If we are masters of the Congresses, of the legislatures, and of the courts, it is our job to oversee them. And the fact they're running amok is our fault. And if you don't feel informed enough, that's what we're here for. Again, constitutionstudy.com. Find these articles. These are information. They've got quotes. They've got links. There's details. You can educate yourself and use that information to defend your rights. I'm also going to point you to constitutionscholars.com. That's a community that is gathering where Constitution scholars can get together and read and study and learn from each other. Learn how to exercise our rights. Learn how to use the Constitution to take control from those who are perverting it. To how to do it legally and preferably without violence. So please head to those two websites, check it out. If you like the work that we're doing and you want to support it, please be my guest. You can buy a book, you can buy a shirt, you can donate to the cause. Everything you donate to the Constitution Study website goes to keeping this podcast and my radio program going. So if you want to help, please do. If you want to get engaged and you want to help, check out the sites. If you want more, contact me through one of the websites. I'll help you however I can. We're fighting for the soul of a nation. We're fighting not for our rights and liberty, but for our children's and the following generations. Will we fight with the tools we have while the fight is still relatively risk-free? Oh, sure, people will call you names. You may get deplatformed. You may even lose a job. It's unlikely you'll lose a limb, and it's unlikely you'll lose your house or your life. But if we don't deal with this now, while it is big and it's growing, but it's still manageable, if we won't deal with it now, our children's blood will be required to restore liberty. And I don't know about you, but I don't want that on my conscience. So again, check out these websites, find out how you can do more, be in touch, get engaged with others, and then come back here and we'll discuss something else the next time on the Constitution Study.